We're live.
Okay, we're back dealing with H-230, which has to do with mechanism to reduce suicide, changes in Vermont firearms laws. For those of you who we don't get to today, I apologize. We were very ambitious in the schedule. We'll pick up with this bill. What day is it next week?
We're doing it next.
And you'll
Wednesday
be, next Wednesday, you'll
at
be
10:30.
we'll follow the same order here as here, and then if other people want to be heard on the bill, they should contact Peggy. If your name's not already on the list, but if your name's on the list, we'll hear from you either today or tomorrow, or excuse me, next Wednesday. We're first witness after the break is Judge Zone, and Judge, would love to hear your thoughts on this bill.
Thank you. Good morning. Tom Zone, Chief Superior Judge. The first thing I would comment on is that it's important to keep in mind that this procedure for ERPOs is a separate and distinct procedure than that for relief from abuse orders. And Senator Sears, you touched on this earlier during the testimony. And what that means is a victim of domestic violence does have the ability to petition for a relief from abuse order 24/7, 365, and that can also include taking firearms and having them relinquished from a defendant in those proceedings on an ex parte order. And so I don't want there to be any confusion that somehow these two things are put together, because they are separate and they are individual roads for different statutory frameworks for protection of individuals.
Okay.
When you're looking at the changes that are being proposed and based on the questions, would it be helpful if I explained to the committee, Senator Sears, I think your question was, what happens at 10 o'clock at night? If I explain the way these currently? So
Yeah, that's my question. What happens at 10 o'clock at night? Who checks out the veracity of the claim by the family member, and whether or not there's reason to remove for 14 days the firearms from that individual?
currently, the procedure is a procedure where an individual who believes there may be a basis for an ERPO would either speak to a law enforcement officer or perhaps can go directly to the state's attorney. The state's attorney would be the entity that prepares the application and compiles the affidavits. If there's a belief that there needs to be additional investigation or additional facts, that would be in the control of the state's attorney to work with law enforcement to put together the package. It's not unlike, for instance, a search warrant. The state's attorney would work with law enforcement, put the paperwork together, and then the next step is it goes to the judge. Let's say it's 10 o'clock at night. The state's attorney has reviewed the information, and they decide that based upon the information obtained and the affidavits that they're going to be pursuing the ERPO. They would then contact the judge directly. The judge would then get the paperwork. Generally, it would be scanned and emailed to the judge. The judge would review that paperwork, and he or she would then make a determination as to whether or not the standards under Title 13, 4054 for an ex parte emergency ERPO have been met. The judge would issue that order and then email the order back to the state's attorney and law enforcement, and they would move on from that point. There may be circumstances that never reach the judge. If someone goes to the state's attorney and says, here's some facts, I think there should be an ERPO, that's up to the state's attorney whether to go forward. If the state's attorney declines at that point, well, then that process would not go forward and the judge would not be contacted. The process for relief from abuse, well, let me ask, are there any questions about that process?
No.
The process for relief from abuse orders, 10 o'clock at night, is that an individual who is seeking protection would contact an 800 number, I believe it is, and they would get an after hours call center. The individual would then call them back, and then the individual working for the court, and then they would you would have the petitioner go forward. The petitioner would dictate their affidavit. The affidavit would be taken down by the person who works for the courts. The individual who works for the courts, after that, the paperwork was complete with the petition and the affidavit, would then call the judge, read the information to the judge. The judge then issues an order based upon that, whether it's in a grant or a denial. The judge will issue an order based upon what he or she has been told. And the worker would then send it out for service for law enforcement. So that's the way the two processes go. You have asked about the question about who checks on it. The court, the judge at 10 o'clock at night does not have the ability to determine, have a hearing, if you will, on, well, is everything in this affidavit true? Is the veracity there? And so in the former circumstance, I think the answer would be that the state's attorney and law enforcement are the ones who would verify any information that comes to them.
But under the new law, who checks the veracity of the complaint?
That the law enforcement would no longer be checking it. And so it would be much like we have for relief from abuse orders now. When a judge is looking at a relief from abuse order, there is no, I would say, challenge, if you will, to credibility or veracity. And in many ways, the judge has to accept the facts that are set forth. If someone says, I am married to Joe Smith has firearms, Joe Smith has assaulted me, and Joe Smith has threatened to harm himself, generally that the court would accept those because there's no challenge to that. There's nothing to check the veracity.
That's a relief from abuse order, but this is different.
Well, this would be, it would essentially, the process that's being proposed would make the temporary orders, we would be utilizing the relief from abuse procedures in terms of, it would be that after hours worker who would work with the petitioner to make sure that we got it. And so we would not have the state's attorney to be involved at that point, in which case it would be very similar to seeking and obtaining a relief from abuse order.
Well, that's a helpful explanation, but my example was the teenage daughter who the father just took the phone away from because she was using it in some manner that he didn't approve of, and I'm paying for the damn phone and I'm going to take it away from you. What's to prevent the daughter from calling? Would they be calling the judge or calling an 800 number?
They would be calling the court worker, who would then take the information and present it to the judge. And on the situation that you have outlined, the judge, unless it's in the affidavit, would have no idea about the cell phone issues or anything else. We would be basing it solely on the information we're presenting.
And the father would have no opportunity to rebut the claims.
There is no opportunity to address the credibility or address the issue with an ERPO. The opportunity is after the 14 day within the 14 days at the hearing. That is the opportunity to address it.
So and I'm going to ask another question because I'm on the Appropriations Committee. We're already short 11 staff. Can you handle this new duty?
I've spoken with Lori Canty, the Chief of Trial Court Operations. We believe that this would lead to an increase in calls afterwards at night. It is potential that there would have to be an additional staff person put on for the after hours calls. But at this time, we do not believe we're in a position to assess whether or not it would be something that we would have, how many hours or what it is. We can't put a number on it because we don't know what the increase would be. And so it would be, Lori's indication was it would be in many ways guesswork to do that. It could be as minimal as several $1,000s. It could be up to 15 or 20,000, I understand, but we can't put anything on it right now because we don't know what the impact would be.
Thank you. Are there other questions for Judge Zoning? You've been very helpful, Judge.
There was other questions asked about current family or household members. And I thought it might be helpful to understand, I know the reason for that is under the current definition in relief from abuse orders for family or household member, or for household member, it says who have at any or for any period of time lived together. And I think the intent here is that you want to get rid of the situation where your college roommate 30 years later who lived with you a year, and I use that as an extreme example, but it really is, if you use that language, there's no time limit on it. That someone would qualify as a household member. And so it appears as though this was done in an attempt to make sure that you don't have the possibility of someone who has, if you will, a stale relationship.
Judge Zoney, I appreciate that. I'm wondering on the other end of it, it's as was pointed out to us by Eric, it's in present tense now that the relationship is based on a relationship that exists. And he seemed to think that even a relationship that had ended the previous week would not be fresh or would be stale. How would you square that circle?
I think that Eric is, when he's looking at the tense and the plain and unambiguous language, present means present. You could consider adding language that would be, for instance, like language that's in the relief from abuse orders for venue, where it talks about you can file it in the county where I think plaintiff resides or defendant, or the county where I think plaintiff has fled to avoid abuse. And so if you have a concern about those circumstances, you could potentially add presently living or has fled or had been living and fled to avoid abuse. I think you might be able to address it that way, which would seemingly take care of those circumstances.
Well, I'm thinking of a situation where someone hasn't necessarily fled, but the relationship broke up, and then they're living in different places, and a couple of weeks later it develops into a situation of potential harm. So would language saying has recently lived together, something like that?
That would certainly be helpful if that's if the policy is to allow those individuals to file. Recently would be a word. It would be one that is imprecise in its impact, but it would provide a flexibility. You could also put a specific time limit on. Mm-hmm. In many ways, it reminds me of your earlier discussion today about close proximity and how that's defined, which right. is, I think Eric was right on target with that. And it really requires a case-by-case assessment. And so I think recently could be there, but it does bring with it, obviously, some ambiguity.
Thank you, Judge.
Thank you, Judge.
The only other comment I would make is I also would identify, and I agree with the Attorney General on the language on as far as the state's attorney or Attorney General filing. And I'm not sure if the committee believes it would be appropriate, as she said, just to have the state's attorney. But I think that needs to be tightened up a little bit. For instance, on section 5, page 9, the line 8 is where it says that upon line 17, where a petition has been filed, the state's attorney or attorney general shall be substituted as the plaintiff. I would suggest that after state's attorney, it says the state's attorney in the county where the petition is filed. It should be clear what state's attorney. And that also comes forward again on page 10, on line 10, but I would recommend including in the county where the petition is filed. And if you delete the attorney general from there, that's fine. That's up to that's a policy decision. But in the language about where on page 9, line 8 through 10, where it says that the court has to send a copy of the petition to the state's attorney or the attorney general. It shouldn't be up to the court to decide which one gets it. And so again, I would carry forward the language with state's attorney in the county where the petition is filed. And if you're going to keep the attorney general in there, I would put an and to make both of them get it and let them decide who's going to go forward. Or you can go with what the attorney general recommended, and that is just have the state's attorney be the one to
We
substitute.
do this section of the bill, I would suggest we do what the Attorney General suggested.
And in which case, I would just suggest adding in the county where the petition is filed for clarity.
Yeah. That makes sense.
If there's any questions, I'd be happy to answer them. Otherwise, that's all I have at this time.
Thank you. Appreciate your time,
Thank you.
as
Have a good
always.
day, everyone.
You too. Our next witness is Chris Bradley, President of Vermont Federation of Sportsmen's Clubs. Welcome, Chris.
Thank you. My pleasure to be here. Thank you for the invitation. For the record, my name is Chris Bradley. I'm the President and Executive Director of the Vermont Federation of Sportsmen's Clubs. The Federation as an organization and as individuals are fully aware of the nexus between firearms and suicide, and we've worked to address that. For example, we worked extensively on the Vermont Gun Shop Project until that effort was no longer funded by VDMH. Jumping into sections 1 to 2, findings and legislative purpose. In reviewing this section, we note that these listed facts do not mention that the biggest risk factor reported among Vermont deaths by suicide was related to people having a mental health diagnosis, something that was present in 68% of reported suicides in the last report dated 2017-2018. We note that this section does not tell us how many times a Vermonter in crisis went to a gun store, bought a firearm, and then went home and used it to commit suicide. We only know that anecdotally, testimony before the House Committee on Healthcare revealed only 2 such events in the past 10 years. We note that this section does not tell us if a person committing suicide with a firearm already owned that firearm or otherwise had unfettered access to it. We further note that this section does not inform us how many times a person committed suicide because they had a terminal illness. In considering a bill to reduce suicides, these are some very significant numbers that we should know. And yet not only do we not know them, a simple amendment that would have allowed this data to be captured moving forward was voted down by the majority in the House. And we ask why. Regarding section 3, secure firearm storage, we need to be crystal clear here that laws which require firearms to be locked up or made inoperable was struck down in 2008 by the Supreme Court of the United States in District of Columbia v. Heller, as any such law does not allow the use of that firearm for self-defense. I quote from the Heller decision, quote, similarly, the requirement that any lawful firearm in the home be disassembled or bound by a trigger lock makes it impossible for citizens to use arms for the core lawful purpose of self-defense and is hence unconstitutional. This was decided in 2008. That is the written opinion of the highest court in our land. That sentence tells us that it is completely unconstitutional to force citizens to lock up their firearms, yet that is precisely what section 3 of H 230 dictates. Moving beyond Heller, we consider section 3 under SCOTUS's decision in New York State Rifle Pistol v. Bruin. Under Bruin, any existing or proposed law that impacts the core of the Second Amendment must be deemed to be presumptively unconstitutional unless the government can prove that laws align with historical tests and traditions of our country's founding. As an aside here, at the time of our country's founding, repeating firearms were in existence and our founders were aware of them. Historians have examined this and other than laws that speak to how excessive amounts of gunpowder should be stored, which has little to, if anything, to do with the storage of firearms. There are no analogous laws that support forcing an honest and law-abiding citizen to keep their firearms locked up when not in use. To be clear on this point, the Federation does support safe storage. We do not want to see accidents with firearms, and it is clear from statistics that Vermonters who own firearms are careful with them. Section 3 fails constitutional muster on not one but two SCOTUS decisions, and there is simply no way that it can be enforced. By the way, if you have questions as I go through, please don't hesitate.
Thank you.
Sections 4 to 8, changes to extreme risk protection order laws or ERPO laws. While we see merit in considering the addition of a family member to the list of those who may file a petition for an ERPO, we are not aware of any situation to date where a family member contacted a state's attorney or the attorney general with an ERPO concern. That concern was rebuffed, and the person in question then immediately went on and did something. We most assuredly agree that a family member is likely to be the first person to detect who is at risk of harming themselves or others, and evidence points to the fact that this reporting is how the majority of ERPOs get handled and initiated today. However, we feel strongly that bringing extreme action should require some level of involvement and vetting by law enforcement, which is why this bill was originally written as it was. Won't this have a potential negative impact on the existing court backlog? Regarding the addition of household member, we feel that this definition is too broad, as it encompasses renters, roommates, ex-partners, and even ex-spouses, to name a few. Again, we ask, are there situations where requests to the state's attorney or the attorney general has failed to intercede when the facts warranted it from whatever source? The specific reference to the constitutionality of the extreme risk protection orders, we need to alert you of the case of CW v. CN, which was decided on December 22nd of 2022 by the New York Supreme Court, and which involved the constitutionality of that state's ERPO when examined under Bruin. That opinion stated the following, I quote, "The question presented is whether CPLR Article 63A, which is the Extreme Risk Protection Order statute, sufficiently protects if New York citizens' due process rights when, as here, the state denies a fundamental right, to wit, by infringing on that citizen's right to keep and bear arms under the Second Amendment of the United States Constitution. This court holds that CPLR 63A does not sufficiently protect the citizens' rights and is therefore unconstitutional. According to federal law, property cannot be taken from a defendant without that defendant having the opportunity to defend themselves. Yet this is exactly what happens in Ex parte and 13 VSA 4054, which is our extreme risk protection temporary relief. And it is also exactly what happens in 15 VSA 1104, which is the domestic relations abuse prevention emergency relief. In the strongest possible terms, it is the belief of the Federation that the failure to recognize the concept of due process in these referenced statutes make them both unconstitutional. With 13 VSA 4054 before you in regards to a suggested amendment, you may well have a duty to correct this error as you contemplate other changes. Further than that, when the ERPO statutes were first considered by this committee, and they originated in this body right here, and we had a number of discussions about them. When it left, after a great deal of discussion, it was determined that the standard of evidence for both a temporary ERPO and a final ERPO should be clear and convincing. We supported that bill as it left the Senate because the Senate voted for that version. Subsequently, however, the House changed the standard of evidence to be preponderance for a temporary ERPO order, which caused us to drop support as that standard is simply too low. It is, as Judge Grierson put it, the weight of a feather placed on one side of a balanced scale. I will therefore, I must mention that we seem to have a disparity between our domestic violence statutes, which have a preponderance as both the standard and final, as well as ERPO in comparison to ERPO, which has preponderance for temporary, yet clear and convincing for a final. Both of these statutes are theoretically somewhat in parallel. Section 9, waiting periods. When I testified on this bill in House Committee on Healthcare, they were still undecided as to whether the section should require a 48 or a 72-hour waiting period. Regarding either waiting period, whatever waiting period is chosen, that waiting period plus 5 minutes will defeat it. And a waiting period means nothing when lethal means are already owned. For data from the RAND Corporation, there is apparently no conclusive study about the effectiveness of one waiting period over another for a person who is intent on suicide beyond conjecture. The truth is, the vast majority of suicides committed by firearms are done with firearms already owned, not firearms just purchased, a situation that this bill does not address at all. For the period of time from 2014 to 2023, the NICS system recorded that there were 440,881 completed background checks on the purchase of firearms in Vermont. That's an average of 44,000 a year, an average of 3,674 a month, an average of 122 a day, or almost 5 per hour for a 24-hour day. Against a very small number of people who are intent on killing themselves buying a firearm across a 10-year period, there were 440,879 other purchasers who apparently did not have that in mind. A significant point to be made here is that the number of Vermont homes that have firearms in them, there are a number, 47% is what I keep hearing, which means there are a significant number of Vermonters who already have access to lethal means. We ask, if the sole point of this bill is to stop people who do not own guns from buying one so that they can kill themselves with it, what is the point of subjecting an already existing firearm owner to any waiting period? How would we measure the tragedy of someone who had an immediate need to purchase a firearm for their defense because of a threat of a known assailant, but were unable to purchase one because of a waiting period, and then were killed by that known assailant? As noted above, Vermonters buy an average of 44,088 guns per year. Since 1998, Vermont has used the FBI's NICS system for background checks. Between 1998 and 2010, 229,624 firearm checks were sold in Vermont. Pass those, please. Were sold in Vermont, indicating that there were at least that number of firearms sold. If we assume that no guns existed in Vermont prior to 1998, and then graphing the increase of firearms in Vermont per NICS background check data, we see the following. It's a steady increase approaching 45 degrees of more firearms in Vermont. In comparison, below is the number of suicides by firearm in Vermont across the same period. What we see is that despite the addition of 376,409 additional firearms into Vermont, there was no appreciable impact on suicides whatsoever. They ranged from 70 to a low of approximately 50 across that same period. There was no correlation that we can see. I conclude with the following thoughts. First, the fastest growing demographic of new gun owners are people of color, with purchases of females exceeding purchases by males, and data showing that a significant portion of crime is against people of color. Women overall are a high demographic of new firearms purchases. Second, if Vermont ever establishes a waiting period, the long history of gun shows here in Vermont will be dealt a death blow. when, to the best of our knowledge, there is not a single story in Vermont where a gun show was used to purchase a firearm that was then immediately used by the purchaser to kill themselves or harm others. Gun shows are very popular amongst the sporting communities here in Vermont. They fully conform to state and federal laws, and they bring much needed revenue to local economies. Finally, I must beat the drum of unconstitutionality one last time. In all my research to date, I have yet to find an active challenge to any waiting period law under the Bruin decision. What I did find, however, was the case of Sylvester v. Harris. In 2014, a challenge was made to California's 10-day waiting period law. This case was heard in the United States District Court of California, which ruled in 2014 that California's law was unconstitutional. In making that ruling, the opinion stated, defendant has identified no laws in existence at or near 1791, which is the founding, or 1868, the 14th Amendment ratification, that imposed a waiting period of any duration between the time of purchase and the time of possession of a firearm. In the final order, the district court ruled, the court has found that the 10-day waiting periods of penal code violate the Second Amendment. Upon receiving this verdict, this case was immediately appealed by the California to the Ninth Circuit. As was expected, the Ninth Circuit overruled the lower court, and they did so by using a two-step means-ends test and something called intermediate scrutiny. That two-step means-ends test and intermediate scrutiny has been specifically ruled as invalid by SCOTUS when dealing with Second Amendment and rights via the New York State v. Bruin decision. In making that ruling, the Supreme Court directed that the proper method of evaluating Second Amendment laws was a close examination of text, history, and tradition, i.e. historical analog, of what the founders had in mind at the founding of our country. Under Bruin, and as the district court pointed out, there was no historical analog to having a waiting period to purchase a gun at the time of our founding, and it therefore ruled the law as being unconstitutional. We also know that in order to overrule the district court's decision, the Ninth Circuit used a testing scheme, which SCOTUS has now specifically ruled as being incorrect. That decision was then reviewed in 2018 by SCOTUS and Sylvester v. Becerra, which denied certiorari. A dissenting opinion, however, in that decision was written by Judge Clarence Thomas, who stated the following: the Ninth Circuit's deviation from ordinary principles of law is unfortunate, though not surprising. Its dismissive treatment of petitioner's challenge is emblematic of a larger trend. As I have already explained, the lower courts are resisting the court's decision in Heller and McDonald and are failing to protect the Second Amendment to the same extent that they protect other constitutional rights. He also stated, nearly 8 years ago, this court declared that the Second Amendment is not, quote, a second-class right subject to an entirely different body of rules than other Bill of Rights guarantees. By refusing to review decisions like the one below, we undermine that declaration. Because I still believe that the Second Amendment cannot be, quote, singled out for special and especially unfavorable treatment, end quote, I respectfully dissent from the denial of certiorari. Under the Bruin lens, and given the strength of Judge Thomas's statement, coupled with the renewed interest in Second Amendment by the Supreme Court post-Bruin, it must be seen that a waiting period is unconstitutional, at least for those who already own a firearm, and likely for new purchasers as well. The ability to defend oneself is a right, and as you consider a waiting period, I remind the committee of a quote from Dr. Martin Luther King: "The right delayed is a right denied." Thank you for your opportunity to speak. If you have any questions, I'd be happy to answer them.
Well, I'm going to start with a comment and a couple of questions.
Yes, sir.
But my comment has to do with constitutionality, and I suspect we're going to hear from a lot of people about why it's unconstitutional, why it's not, why it is constitutional. And I would go with Eric's fine work on this, and particularly the concurring opinion of Justice Kavanaugh, joined by Justice Roberts, which, along with the other three members of the court, would be a majority of the court. And I take heart in the fact that what it basically said, like most rights, the right secured by the Second Amendment is not unlimited. Now, if we took the argument that it wasn't there when the founding fathers wrote the Second Amendment, then we would conclude that denying me the right to carry a loaded firearm on an airplane, since there were no airplanes in 1700s, is unconstitutional, and that I should have a right to unfettered access to that airplane. My guess in that ridiculous situation is that Roberts and Kavanaugh would probably join with the other three, and by a majority opinion of the Supreme Court would say, no, that's reasonable that you not carry a loaded firearm on an airplane. And quite frankly, I wouldn't want to fly on a plane where anybody could bring a loaded firearm. So in terms of what's constitutional, what's not, the one thing we can be sure of is we don't know what the US Supreme Court would find, and we don't have the ability to go down to Washington, sit down with the 9 members and say, is this constitutional or not? So I think it's all guesswork, and we're going to hear it on both sides. I'm not picking on you.
Oh, no.
This is a statement for, for all future witnesses on this bill. I think, personally, I thought your argument about on the Europol section, about the standard of preponderance of the evidence versus clear and convincing evidence is a very an important point that we need to keep in mind. I found that particularly helpful, and I want to thank you for raising that.
May I respond, Senator?
Sure.
Of all the amendments, there was only one that our founders used the phrase shall not be infringed. If we make a parallel with the First Amendment, and I think that's a good guide for as we look at the Second Amendment, because there's no question over time, courts have taken liberties in how to interpret what the Second Amendment is. And so now we've got a guidepost. That guidepost was actually established in Heller because they used text and tradition in Heller. But other courts did not really pick up on that. So now we have Bruin that actually went back and said, look at what we did in Heller in text history and tradition, because that's how we resolved Heller. I guess the question I would ask, Senator, as far as the First Amendment goes, I don't think anybody in this room would accept you can say whatever you'd like, but you have to wait 3 days before you can say it, because
I'm not arguing on that. Again, what is constitutional, what's not constitutional, until they make a decision in Washington.
it is very much.
We don't know, that's for sure.
Yes, sir.
At either side, both sides make convincing arguments, I'm sure, but I don't know.
If I might suggest.
I can assume that something might be. Senator.
Yeah, I mean, I hear you on, your freedom of speech argument, and we have a right to liberty, and we can hold someone for 72 hours on a mental health hold. So I think there's a lot of different ways to interpret this. But my question, your testimony is that you're unaware of any instance in which a family member called law enforcement for an emergency relief protective order and were not granted it or were dismissed. Is that correct?
That is correct.
Where does this statistic come from?
Simply, I listened to all the healthcare information. I did as much research. Is there information that refutes that?
I don't know. I'm just wondering where the statistic comes from. I'm wondering if you've spoken to every person who reached out to law enforcement to find out if they were dismissed or ignored or felt.
It's an outstanding question, Senator, and we're going to have some people here that might be able to answer that. Certainly state's attorneys or the Attorney General. Right now today, I believe the law allows anybody, a neighbor, the mailman, to make an ERPO request to a law enforcement, a state's attorney or the Attorney General. that strikes me as being very prudent to allow some sort of vetting and even to get the arguments and affidavit correct. As I understand this now under IRPO, anybody can make this filing. And as soon as the filing is hit, which I believe would be after the ex parte has been decided, it then gets turned over to an attorney. Well, what if they're, it's family members and household members are probably the best decision people to see these things going on. I just don't know, I'm not aware of anything preventing them from moving forward with an IRPO today by going through the appropriate channels. So I don't have specific numbers.
Okay, thank you. Do you have a sense of how many instances a family member simply did not feel comfortable reaching out to law enforcement because of they might have been afraid of what the response would be and therefore just didn't ask for an emergency protective order?
Well, IRPOs are relatively new, only established in 2018. The domestic violence side, I know there's horrible, horrible stories of just intimidation, people not wanting. Take a look at how many times temporary orders are filed and no final order ever happens. That's a very telling statistic. And in fact, a good percentage of temporary orders, I believe, if memory serves, almost a quarter of them are dropped immediately, which honestly, if someone's coming to me and there's nobody to give the other side of the story, all I'm hearing are accusations and no defense. How can you not always have a preponderance of evidence? Yet judges somehow do not always grant domestic violence temporary restraining orders. The number, if memory serves, is about 3,000 per year. I believe something on the order of 400 of those, maybe 600, don't even make it past the initial late night call to the judge.
But you have no idea how many people never called because they were afraid of the response they would get from law enforcement.
You're absolutely right. I have no way to know that.
Thank you.
Senator Bruce.
Thank you. I appreciate your testimony. I wanted to go back to Heller because it seemed to me that in her testimony, the Attorney General was pretty clear that she thought this bill was drafted to be in line with Heller. So there's a specific passage protecting self-defense use of the weapon, which gets you out of the prohibition. And I'm thinking about another line from Heller. So this is a quote from the Heller decision. Nor correspondingly does our analysis suggest the invalidity of laws regulating the storage of firearms to prevent accidents. So directly from Heller. So I'm wondering, your testimony was that you thought this was in contravention of Heller. What would you say to that particular piece of it?
I come back to the Supreme Court being very clear that a firearm that is locked up is not suitable for self-defense. So I guess you were touching upon some interesting proximity discussions, which, and I don't want to get lost in the weeds here. My son has a friend over. I'm down in the living room watching TV. My son is upstairs in his room, goes to the bathroom. A visitor wanders into my bedroom. That's not an illegal entry. He wasn't even supposed to go there, but he's now done something bad with my gun. Another aspect of this is, if anything like that happened downstream, I'd have to think not only are there other statutes that are going to come into play, there's probably a personal lawsuit that's going to come into play.
Well, but I guess to go back to the idea of what we're trying to do with the law, we're trying to change the culture, the gun owning culture, so that more people lock up their weapons. Maybe not 100%, but we're trying to push people as hard as we can to lock up their guns in exactly the situation that you talk about. So in other words, I have children. My children bring children over to the house. So I'm not just I know that my children who are minors are in my home. I also know that other people's children. To me, that suggests additional duties with my firearm. So the idea that I would have a loaded, unsecured weapon in my bedroom while I'm off elsewhere in the house while people are visiting, that seems to me negligent on its face. So it seems to me what this bill is doing is, in a relatively light touch way, it's saying if you don't have children or people who are prohibited, you don't need to worry about this necessarily. It's also saying if this is, in service of preventing an illegal entry or self-defense, you don't have to worry about this. But in a situation where you're just routinely leaving a loaded weapon around, knowing that you have children and their friends over, I do believe we should be at that point stepping in. I don't read Heller as preventing them because it's speaking to the prevention of accidents, not denying self-defense.
And your point is well taken, and I think Senator Sears is spot on. There's going to be a lot of interpretation here, but the whole purpose of the Heller decision had to do with a security guard that was not allowed to keep his own service firearm operable in his house because it was locked or disassembled, separated for ammunition. That was the core of the Heller decision. So I look at it and say, yes, I understand that we want to be careful. Frankly, Senator, I see almost all of this as being an educational issue. We should be educating the significantly low number of firearms accidents happening to Vermont youth when we have over 47% of households with guns in them. I think it's very telling. Vermonters are, we can always do better. Absolutely. But I see this as education. I also see this, in my case, I don't have anybody living with me. But there are biometric locks now. There really isn't any reason to not take a prudent step. And perhaps we make money available for a biometric lock. But at the end of the day, forcing someone to prevent the ability to self-defense is, I think, the core of the Heller decision. And that's exactly where I stand on that. And I may be wrong, but if I have a firearm, the purpose of which is to be locked up in the bedroom, as soon as I leave that bedroom, it's no longer in my immediate control. Did I have to lock it up so the next time I come back into my bedroom, I have to, you can.
I guess it's hard for me. I have 3 girls. Hard for me to see it outside the context of being a parent. So, I don't put things on the front burner of the stove to this day, even though my kids are grown, because that was a common sense provision when I had kids. So the idea that someone would say, in the service of some highly generalized and in some cases, frankly, somewhat hysterical ideas about who might break into my house, I'm going to have a loaded weapon in my bedside table at all times, whether I'm in the house, out of the house, and have my kids around. That just seems to me a place where we have to intervene. And frankly, I don't care whether they thought in 1791 such intervention was necessary. I understand Bruin is the law of the land and we have to go along with it. But, I feel that it's led us so far astray from common sense. When you have a pool, you have to build a fence around because it's an attractive nuisance for children. And guns are more attractive than pools. If a kid sees a gun, they're going to pick it up. So, it seems to me that this is, if not on all fours with Heller, it's respectful of Heller. Bruin, as we've said, is an open question. Thank you.
No, you're most welcome. Thank you for the discussion.
I appreciate your point that education is really important to protecting people and making sure that they recognize firearms as a dangerous tool. Would you support mandatory education for firearms ownership?
Yes, I would.
Thank you.
Much like we have other educational opportunities in school. In fact, there is a separate bill that I believe it got split off from this, and we are interested in that because I'd like to know what the messaging is going to our students concerning firearms.
Okay. Any other questions for Chris? Rory, next bill.
Thank you very much.
Thank you.
Good morning. For the record, I'm Rory Tiba, the former Washington County State's Attorney. I'm currently an attorney working with the Department of State's Attorneys and Sheriffs. There's a lot to cover, and I'd like to just hit on some of the topical questions that were raised earlier, either by other witnesses or by the members of the committee. First, just noting the overall constitutionality. The Department of State's Attorneys and Sheriffs is appreciative of Eric's analysis, and our assessment is in accord with the chair that the concurring opinion of Justice Kavanaugh, joined by Justice Roberts, is probably instructive in terms of the likelihood of laws like this are prevailing in the long term. With that said, I know Senator Sears expressed some concern about the laundry list of findings up front. Some of the findings, particularly findings 8 through 12, were added or worked through on the recommendation of our department with the House Judiciary Committee, namely because this bill in its scope obviously has a public safety component to it, as well as the public health component in trying to avoid suicide here in Vermont. The public safety component, though, is one that has a much longer tradition when you look back at the different regulations and laws that were in effect in either 1791 or in 1868, providing a nexus and rationale for both aspects of the law rooted in public safety, particularly the waiting period, was important. And to that end, the findings and the ATF data available about straw purchases is incredibly troubling. And I know this committee already did work on S4 and is taking action on that, but looking at the number of Vermont firearms that are killing people out of state should give everyone pause. It puts Vermont's own murder rate at a much smaller rate, but Vermont guns are being used to effectuate some of the most violent crimes in our neighboring states. And this is something in terms of waiting period that can disrupt that process of the instant gratification of sending someone in to purchase a firearm, walking away the same day, and then transferring it to a bad actor who intends to use it out of state. Getting into the actual language, the House Judiciary Committee did take a reassessment of the language concerning, in the context of safe storage, what it means to be under someone's control. Representative Lalonde had a preference, I believe, for the Connecticut law and adapted that language here. Our department has suggested looking to the terms of actual constructive possession that are under our existing larceny from the person or possession of stolen property statutes as potential analogs that have a deeper root in Vermont. Overall, we don't take a formal position on that as a department, but that is an alternate if there's concern in the committee about the particular language used. We also had concern about the reference to the display or use of a firearm in a threatening manner by a child. We thought it would be better to just reference that to crime, noting, of course, that aggravated disorderly conduct, criminal threatening disorderly conduct already largely cover that, or even reckless endangerment, where a child may bring a firearm to school, wave it around in some way. Vermont doesn't have a separate, as some other states or jurisdictions would call it, brandishing statute of just merely showing a firearm as being a crime. And so we did have some concern about the ambiguity of what it means to display in a threatening manner.
Where is that?
Page 5, line 6.
Line 6. Thank you.
The Department of State Attorneys and Sheriffs had no objection to the proposal by Attorney General Clark on page 4 of striking that last part on line 13 as to about the rendering a firearm inoperable. Just noting that a lock container equipped with tamper-resistant panic lock or other safety device is sufficiently broad. Our interpretation was safety device could include biometric security features or something else that still enables quick access. Jumping into safe firearm storage is also probably an opportunity to demonstrate, as I think Eric artfully did, there are very limited circumstances and a number of predicates where this actually applies. The first threshold is whether a child or prohibited person is likely to access. There's a lot of households where that's not going to be a direct consideration, or maybe a temporary consideration when grandchildren or children or someone is visiting versus the steady state of how a household operates. So in that sense, there's already a narrowing and tailoring of the statute to a more limited set of circumstances with a more rational public safety or public health benefit. In terms of the actual control or the close proximity, a fundamental question is this: if a firearm is located in another room, is it of any value in an immediate moment of self-defense? If you have to run to a separate level of the home, and it's outside of your immediate proximity or control, doesn't have the same utility. Unlike the Heller case, where this person had to disassemble and secure the firearm in the house at all times, this does not preclude someone carrying a holster or having a holstered weapon at their side, on a table next to them, or again, within some degree of reasonable proximity and control. So unlike Heller, this is not in any way, we would not interpret this in any way to be an outright prohibition on someone having a loaded firearm in a household, even if there are children or prohibited persons there, because the key question is whether it's some degree of positive or affirmative control by the authorized user or owner.
You skipped over charging decisions.
Yes,
And I'm really concerned about that section. I don't ever remember seeing it in criminal law anywhere else. And leaving that in there leads to questions about whether state's attorneys have discretion in other places.
so I think that the House, in the House, we did indicate our preference that that be removed, consistent with the Attorney General's testimony today. I think it's important to note that some prosecutors don't always carry the best reputation, but they're generally not heartless. Look at all the facts and the totality before making decisions. And
I've never seen this before, and that's just.
the only analogous area in law right now that I was able to identify revolves around domestic violence, and it's a dictate to a court that if a domestic violence offense is committed in the presence of a child, it's a factor the court may consider for purposes of sentencing. So it's more at the outcome rather than charging. So it prescribes that could be a mitigating factor. So if this does retain our preference, if it's retained at all, it should be directed to the court as a factor to consider for sentencing, not for the threshold for the Attorney General or the prosecutor to charge. Another important part of the safe storage standard, and one of the reasons why I was identified as a witness for testimony in the House, was a fairly well publicized incident that took place in Barrytown in the last several years, where a young boy ended up killing himself by accessing an unsecured firearm in a residence. And my memorandum on why the state did not file charges did an analysis of reckless endangerment, involuntary manslaughter, and those elements. One of the footnotes in that memo, I think, caught the attention of some members of the House Judiciary, which was Vermont does not presently have a standard for what constitutes safe storage. Our involuntary manslaughter jury instructions continually reference back to this notion of a law, what would a law-abiding citizen do, or the conduct of a law-abiding person. Defining what the standard is for a law-abiding person in terms of firearm storage would certainly help in the context of future decisions about whether to charge in those circumstances, and moreover, will provide a clear standard for civil liability. So there was some discussion, I think, by Senator Norris about, is this toothless that we have a standard without a direct enforcement mechanism unless something bad happens? I think the answer to that is, perhaps nuanced, which is there is merit in that by having a standard that can be relied upon for the analysis of charging when something bad does happen, or also in the context of whatever civil litigation or torts may be brought independent of the criminal justice system. Within the analysis of other charges, certainly this does contemplate criminal charging. There are other offenses that have somewhat different elements, as I mentioned, reckless endangerment, in case someone was injured by result of reckless behavior with respect to the standard. And of course, involuntary manslaughter, if there's criminal negligence that's currently defined by law. I would note, Senator Hughes, you brought up child cruelty offenses. The standard for child cruelty is difficult because it requires generally some sort of purposeful act. And the way in which neglect is referenced is called willful neglect, which is kind of a difficult construct sometimes, but it means that someone has to deliberately ignore a risk or be aware that there's a high risk situation and do nothing about it. So it's more than just carelessness or negligence.
I appreciate that. One other comment I'll make on this section of the bill, which I'm not fond of particularly, but it's part of the bill, is the sign at the bottom of page 6, lines 13 to 17. Reminds me of the click it or ticket program, which entirely infuriates me every time I see that on TV, because they're saying click it or ticket. They don't tell you that part of Vermont law is, unless there's a secondary violation, you can't get charged with click it or ticket. And I think this section indicating that, at the end of it, it kind of says, yeah, it is against the law, or it isn't, but, as long as your failure to securely store firearms is required, may result in criminal prosecution on the person prohibited from purchasing or possessing by a child who's like to gain access to them. It just really, it's fine to have the other 2 warnings, or the other warning about, risk of suicide, death, etc., domestic violence, except I don't have a problem with that.
This is
I just kind of think that's a little It's not really what the bill does, or this section of the bill does.
I do think it goes back to Senator Norris's point, which if it's not going to be a primary offense, how is it affecting the problem? And I think that's one place where it's trying to push the awareness and the culture
It
in.
makes you think it is, but it isn't.
Well, it says may result, which it might if the charging thresholds are met.
But Vermont law doesn't require gun owners to securely store their firearms separately from ammunition in their homes.
If,
Does it?
well,
In the bill, in the rest of this section of the bill, does it actually require?
oh, I see what you're saying. So it's,
That first sentence,
yeah, it's because you're saying unless there's a
unless,
subsequent.
yeah, if you live alone
Mhm.
and nobody ever, you're kind of a hermit, nobody ever comes to visit you.
You could say under Vermont law, failure to securely store firearms is required may result in criminal prosecution
Yeah,
and eliminate the sentence above it.
yeah. I just think it's a personal thing of mine every time I see quick or ticket. You don't get riled up about that.
Click it or ticket? Not as riled up as you, but I do see your point. There are other things, Senator Sears, that get me riled up. I wonder if, so the concern is that this only becomes a crime if something bad happens. What if it was a crime always, but it was only punishable if something bad happened? Does that solve people's concern?
One thing I can say, the original draft that the House considered had I think a $100 misdemeanor fine attached to this. Our alternate suggestion was to look at using Judicial Bureau to have a civil ticket issue if there was a violation, so that would be your lowest level. If there's some happenstance law enforcement contact or someone is involved, that you would have the ability to respond with the discretionary issuance and adjudication through the Judicial Bureau. That also, one thing I noted for the House Judiciary is, of course, if it's a civil ticket offense, that doesn't provide a basis for a search warrant, so it limits law enforcement power where you're not going to be going and applying for a warrant because you think someone's not storing firearms properly. So that was a balance to have some sort of hook for compliance without necessarily inviting more intrusive law enforcement powers than the committees might be willing to grant.
We got about 10 minutes left.
I'll go quickly. I think the last thing I'll maybe end with, and not get two big points left, are really looking at the extreme risk protection orders. I think it's important, and there's some backup documents from the judiciary. These are fairly limited. Statewide, there were less than 50 temporary and final orders issued in the last fiscal year for which data was available. In my former jurisdiction of Washington County, we were the leading jurisdiction with 6 total over the course of the fiscal year. To Senator Bahovsky's point, I'm not sure how many people are not accessing this, either because they don't know that this is an option or because of reluctance to engage with law enforcement. But I think it's one I've gathered, in fact, President Black can talk about this more as a sponsor and advocate for this, but my understanding was the key purpose of this bill was to try to broaden the aperture of who could immediately respond. And certainly in our cases where self-harm is the basis, it has typically been the family members or immediate household members who are living there who are vested with that information and are able to react as quickly as possible. Whether they want to go through law enforcement or not, there's many reasons why people may not want to do that.
Senator.
Well, and I think to your point that in some instances, this is in relation to self-harm, or this is, and we've unfortunately seen instances where family have reached out to law enforcement, and what happened was a wellness check that resulted in someone dying, and not at their own hands, but at the hands of law enforcement. And so I think there's plenty of reasons why people might need another avenue to get their family member or loved one the help that they need. So
Yeah, and to that point, I think there's some concern about potential abuse of this process by individuals. And I'll just say that first and foremost, there are a lot of comparisons made for understandable reasons to RFAs. The RFA process is not always perfect, but I think most of the time the courts are getting it right. Moreover, there are consequences when someone lies or misrepresents one of those hearings. It's never a great thing to be a prosecutor in the position of going or charging someone who's a putative victim, but there are at least 2 occasions where we, in my jurisdiction, my tenure state's attorney, where we prosecuted individuals for providing false statements or false information during the course of an RFA proceeding. One was a law enforcement officer, the other was a complaining witness in a case. So there is recourse when there are lies or omissions and or incorrect data put before the court. The other protective measure here is because if a temporary order is issued, there's almost courts required to give near immediate notification to a state's attorney. And the vetting will begin right away. It's not going to be wait until the day of the hearing, but the first thing that will happen is contacting whoever the complainant was and the witnesses to gather that. And there's an ethical duty, of course. If the prosecutor feels that they cannot prevail or meet the clear and convincing standard, then the case needs to be disposed. And you can see just as much as there are more temporary extremist protection orders issued than final orders. That's some of that vetting or events overtaking it, where someone may be committed and receive mental health treatment where the basis for extremist protection order no longer applies, or other circumstances where there's now been a criminal charge and criminal conditions of release are serving the purpose that the protection order would. The final point I'll make about IRPOs versus RFAs can be incredibly broad. They can restrict access to children, access to property, not going certain places, not being in the same place with somebody. An extremist protection order is much more narrow. We're only dealing with the question of firearms. So we're not dealing with even the same level of restraint that a court can impose based upon the RFA in terms of really inhibiting someone's liberty or ability to go or not go certain places. And the only other comments I have about the waiting period, of course, is to assess it not just for the purposes of how it's viewed in the lens of suicide prevention or mental health nexus, but also in terms of what I would classify as the epidemic of Vermont guns being purchased by individuals with a clean record and then immediately or near contemporaneously transferred to individuals who would otherwise be prohibited from purchasing here. The documents, the ATF reports and excerpts of it are part of the committee documents we submitted, and they're summarized in the findings here. And I think it's pretty compelling to show that while Vermont is lucky to have a relatively low level of gun violence compared to some states, we are certainly complicit in driving the availability of firearms in other jurisdictions.
Senator Mahanski and then Senator.
So the statistics you're presenting sort of to me look like, yes, this is a suicide prevention bill, but it's also a community safety bill.
Absolutely, that's our lens through this. And I think we're in accord with the Attorney General's office in believing that anything that can be done by the legislature to provide a very clear understanding for future courts to interpret what the reasons were for this is important. And again, looking at historical analysis, there's not a lot of public health legislation in the 1790s or 1860s, especially with respect to firearms. There was a lot more about regulating things like gunpowder or storage or just generally public safety laws about what could occur with firearms.
Senator
Do you feel that the 72-hour waiting period would help to prevent straw man purchases?
I think so, because my experience, and this is again based in Washington County, we have 2 licensed firearms dealers that we had reporting from, and they were generally good partners to ATF and others reporting suspected activity. That said, there are still times where those purchases went through and then were later investigated and dealt with. There's a lot of instant gratification. By and large, the profile of someone who's being put up to complete a straw purchase are typically younger people, a lot of women, and they're typically people with substance use disorder, where acquiring a firearm is a barter when they don't have money or don't have the means to acquire whatever substance that they need to avoid going withdrawals. So there's an exploitive nature that goes hand in hand with straw purchases, and removing the sort of instantaneousness or near contemporaneous ability to acquire a firearm would disrupt that cycle where there's not the ability to just go in, walk out, make an exchange, and go on with life. 3 days, I think, has, as Senator Potsky's pointed out, a close nexus to our mental health goals, and I think has a rational, as I think Attorney General Clark put it, there's harmony in the law there. I think that's helpful, and it substantiates that that's not some arbitrary number, that there historically have been findings or view that a 72-hour hold for mental health is appropriate. That can apply here as well. 72 hours would be likely sufficient time to put some distance between that immediacy of someone trying to complete that transaction for a nefarious purpose.
Thanks.
Thank you.
Thank you very much.
We're gonna come back to this bill next week, but Eric, in the meantime, what other states' waiting periods are?
Yes, as long as it's quick, because I'm supposed to be at a press conference now.
Go to your press conference. I'll see you this afternoon.
All right.
Pardon me?
Oh, no.
We're on the same committee this afternoon.